David Sfara is going to be on at 1:30. He's a partner with the firm Giuliano, Richardson, and Sfara out of Woodbury. Actually, a real brilliant guy. He was formerly a partner with the law firm of Carmody and Torrance here in Waterbury. I know him because we're on the board of directors together at the Mattatuck Museum. And his field of practice really is estate and business planning, tax planning, trust allocation, charitable giving. So it's right up my listener's alley. So I'll patiently wait for David's call. I will go. Oh, he's already on. God, this guy's responsible. It's like 1:30 on the button. David, is this you?
Hi, Michael.
First of all, I can't thank you enough for your time. 10 minutes even is just magical to get from a gentleman as intelligent as you are. Okay, so I already plugged you. I did everything I was told. Stick with the points in bold, which I did. David Sfara is formerly a partner with the law firm Carmody and Torrance out of Waterbury. He is now successfully on his own, kicking butt in Woodbury. Dave, tell us a little bit about yourself.
Well, Michael, I have been doing this being estate planning, advising people with regard to estate administration, trust administration, and things of that nature for 36 years now. Hard to believe, but it's been 36 years.
You must have been like 10 when you started.
Spent my first 35 at Carmody and Torrance in Waterbury, and am now happily with two great partners, Rosemary Giuliano and Rick Richardson in Woodbury.
And so today's topic was healthcare power of attorney and living will. What's your take on those documents?
Well, I listened in. I actually turned on the streaming about 15 minutes ago and listened in just to see what you were talking about.
Sure.
So what I thought I could do in the time I have is talk a little bit about the legal documents that address some of the issues that you were discussing.
Okay.
And there are several sort of building blocks of an estate plan, including wills, trust agreements, powers of attorney, and healthcare directives. But let's start at the bottom of that list because that's the focus of today's conversation. The healthcare directives. And so one of the things I thought I could do would be to clarify some of the nomenclature. And distinguish between a power of attorney and a healthcare document.
Okay. Nice job. You know exactly what we're talking about.
Let me just start with the power of attorney, actually, because a power of attorney is a document that appoints, in which you, as the principal, appoints someone else as your agent. And there are many forms of powers of attorney that can be used for many different purposes. We have something called a statutory power of attorney in Connecticut, and it's exactly that. If you look at the right statute, you'll see the power of attorney form, and you can get it in your stationery store, or you can have your lawyer have you prepared for you.
I would prefer the lawyer other than the Staples, but okay.
For power of attorney, so basically it can be very broad or it can be very narrow. Like you were talking about, it can be limited to certain specific acts, or it can be very broad and allow you to do just about anything that the person who's granting the power of attorney can do.
Right.
So you have the person who's giving the power of attorney, and then you have the person or persons who are designated, and they are called attorneys in fact. So it's not an attorney at law, it's an attorney in fact, the person you designate to do something for you. So, not to make it complicated, but
that's why you're on the air. You're the expert. Take it away.
So the purpose is, though, if you're unable to do something yourself, you appoint someone else who can sign for you, or who can authorize something to be done for you. And an example of that would be if you went on a trip and you had to do a real estate closing and you wanted someone to be able to attend the closing for you and sign documents, you'd give them a power of attorney to handle the transaction. In an estate planning context, it's usually somewhat different than that. It's to address the unknown in terms of what might occur at a point when you're unable to act for yourself because you're incapacitated, or just because it's too much for you. And so, and you also don't know exactly what the transaction would be, and that would call for a document that has broader powers. And so our statutory form power of attorney almost allows the agent to do whatever the person who's giving the power of attorney could do in person. So, and that power can extend until the person's incapacitated, or it can extend beyond when a person's incapacitated. And when it's beyond incapacity, it's a durable power of attorney. because the old law was that if you became incapacitated, a power of attorney was revoked because you were no longer able to grant someone the power to act for you, to sign legal documents. But the law now is that if you say in the power of attorney that it continues beyond incapacity, then it's called a durable power of attorney, and even if you are unable to make legal decisions, the attorney, in fact, the person you're giving the power of attorney to, can act for you, and that's usually when it's needed.
Right.
So the elderly parents who have a medical event, they can't do things for themselves, they need someone to sign for them to take action. That's when the power of attorney is needed. So if you had a power that was not durable, then it would terminate at that point in time.
Beautifully put.
So that's the power of attorney. Now, the health care documents are they're also created by statute. We have a series of statutes in Connecticut that deal with health care decisions, and they allow you to. There are actually several parts of it, and I usually use one document that is 4 separate documents combined, all of them specifically authorized by Connecticut statutes. So when my healthcare document, I didn't really draft a word of it, except for the names of the people and the address of the people who go into it, because I'm following the statutory form, usually, because that's what the healthcare providers are used to saying. Having said that, the law says that you can leave healthcare directions of any type, but then they give you an example of what you can say. But it doesn't say you're limited to that. So you can give directions as to how you want things to be handled for healthcare purposes. But most people tend to follow the statutory form, unless they have something very specific they want to deal with.
Okay.
So what are the parts of that form? One is that you may designate a healthcare representative, and that is what you were earlier referring to as a power of attorney for healthcare decisions, or in some states it's called a healthcare proxy.
Proxy, right, or
right.
agent. Or surrogate.
So the other thing that's important is the laws on this vary from state to state. So we have 50 states. Each state has its own set of laws on these healthcare decisions. Mm-hmm. Usually, if the healthcare document is good in one state, another state's law will accept it. It's called reciprocity. If it's good in your state where you sign it, then if you're in Florida and it's presented, it's usually going to work there as well. But having said that, if you move to Florida or if you move to another state, usually it's a good idea to have one done in compliance with the law of that state, because that's what the doctors and other healthcare providers.
And there's not reciprocity if you have it drawn up in Connecticut and then you're a snowbird and you go down to Florida?
There is reciprocity. Generally, the laws are that it will, if it's good in the state where you sign it, it'll be accepted where you go.
Okay.
The only problem with that is when you go somewhere else, they're not used to seeing your form. They're used to seeing their form.
Their state statute form. Got it. Okay.
So it's better to have one.
People, I told you got to be listening to this guy.
It's better to have one for every state in which you have a residence, for sure. Mm-hmm. But, you don't. Usually people don't do one every time they go on vacation to Illinois or something. They have an Illinois healthcare document.
Right.
But I've had clients ask me whether I could do one that's good in all 50 states. And I have to tell them that, each state has a different document.
Yeah, there is no blue sky power of attorney.
There would be 50 different documents. Now, chances are the one we do in Connecticut will be good in Illinois or Massachusetts, but and will be respected there. But the laws may be a little different.
Right.
So the first part of the healthcare document is healthcare representative, and that person can speak for you with respect to your healthcare decisions, either a procedure that needs to be performed, or giving consent or not giving consent to a procedure that needs to be performed, or with respect to your wishes on the withdrawal of life support system procedures. And so those are the two things that the healthcare representative does. So it's like a power of attorney, but it's specifically for those healthcare decisions.
Got it.
And the other thing that's important about that is if you can speak for yourself, then they're going to listen to you, not to your healthcare representative. because you have the control. It doesn't trump your own wishes. It authorizes someone to act in the event that you can't act for yourself.
Right, on your behalf.
Right, to act on your behalf if you can't do it yourself. Same thing with a power of attorney. If you give someone a power of attorney, it doesn't give them the right to do what you don't want them to do.
Right.
It gives them the right to act for you in your absence. So the second part of the healthcare document is the living will, and it's actually in my document. It's the first part, but since we talked about powers of attorney, I wanted to compare the healthcare representative with the regular power of attorney.
Right.
So the living will is an expression of your wishes if you're permanently incapacitated, in a persistent vegetative state, or permanently unconscious. So if you're not going to wake up, basically, then you can say which procedures you would like to have continued, or which ones you do not want to have continued. Mm-hmm. So you may not want to have the life be kept alive by machine if you're not going to wake up. And most people, that is their preference, but it doesn't have to be your preference. You can say whatever you wish, but there is the form that's in the statute, and the one that I follow, that says that in the event of incapacity, you don't, and if you're not only incapacity, if you're in a persistent vegetative state or permanently unconscious, you don't want certain types of procedures to be continued, such as pulmonary resuscitation, you know, all the extraordinary means of keeping you alive.
So no rip the shirt open, clear, zap. You
okay,
just say no.
Okay,
no.
Well, there's a different. That's a do not resuscitate. Do not resuscitate is not in your living will. That's a different order, and that's with your healthcare provider, and it usually requires you to have a wristband. Otherwise, they're going to assume that they should resuscitate you. If
Okay. See, that's something new. That's what I didn't know. That needs to be with your physician as well as written in your power of attorney?
Okay, so let's back up for a second.
Okay.
So the living will is for certain types of medical procedures, such as cardiopulmonary resuscitation, artificial means of providing nutrition and hydration, artificial respiration, that if you didn't have those procedures, the medical diagnosis would be that your life would end in some relatively short term. The likelihood is. So they can keep you alive by these machines, but if you're not going to wake up, it's your expression that I really don't want to be kept alive by a machine because I'm never going to enjoy life again. So that's your wish. You have to reach that threshold before that would apply. So if someone says, well, if we think we can we can bring him back if we keep him alive by these artificial means, they're not going to apply your living will. But if they say you're never going to wake up or you're never going to get better, and you're in a terminal condition, you're not going to get better, then they would generally follow what you've expressed in your living will. Okay, so that's sort of a longer, it's an immediate thing, but it's for a longer term diagnosis.
Okay.
A do not resuscitate order is something different, which is that if you, the EMTs are looking at you and you're unconscious, are you supposed to be resuscitated or not? And you can have a do not resuscitate order, and I'm not the expert on this because this is really a medical procedure.
And I'm not either.
But that's something that you need to have usually on your person so that the people who are administering that know that your order, which presumably is approved by your physician, is that you not be resuscitated. And that's something that generally lawyers don't handle, but the doctors do.
Got it.
Okay, so and then actually there are two other parts of your healthcare document, and I'll do those quickly because we're probably already at the end of my time.
No worries. You got plenty of time. You're David Sfara.
The other two parts. One, you can appoint a conservator in advance. So if you become incapacitated, so you're not able to legally make decisions for yourself, either you have Alzheimer's or there's something else that impairs your decision making or your ability to care for yourself, any type of mental illness or anything else that could affect your ability to care for yourself, then the probate court could become involved to appoint someone to have legal power to take care of your person, that's conservator of the person, or your assets, that's conservator of the estate. It could be the same person, it could be two different people for each of those two jobs. That and usually that petition to have a conservator appointed would be brought by someone in the family who says, mom or dad or brother or sister, whomever can't act because they're incapacitated. We have legal things we need to do. There isn't a power of attorney. There aren't other means of taking care of the person, so we need to have the court intervene so that someone has legal authority to sign documents and do things. So we go to court to have someone appointed. What the healthcare document allows you to do is for you to decide who that should be, because otherwise it's going to be a decision of the court after hearing from the family or other close persons about who they think it should be. But usually the choice would be, I'd rather choose who will take care of me in that event, not someone else. And that's what you can do in your health care document. You can choose in advance, if I become incapacitated, I would like my son John to be, Michael to be my conservator of the person, Michael to be conservator of the estate, for example.
Got it.
And then the last part is you can make an anatomical gift. And that's different from your driver's license, but you can indicate that you would like to make a gift of some or all of your body parts for medical research or for any other useful purpose, for organ donation or whatever. And that could be done in your health care document. And I'd say about 50% of my clients do it, and 50% leave that part blank. Don't include it.
Organ donors, eyes, stuff like that.
Right.
Now, estate planning is where you really shine, and it's actually known. I know clients that are clients of yours, and you're not loud at all. You're very low key. You're the underground guru for the estate planning. How do people find you if they're listening and they need you?
Most of my new business, most of my business is with my long-term client, my clients who've been for a long time. But most of the new business is from other people who know me, is by referral. Mm-hmm. And that's, I think, the best way to get to know people.
I couldn't agree with you more. A referral is a warm lead. The person already trusts you. It's not awkward in the first, beginning stages where you're like soliciting. You and I don't solicit. We just give advice, and people trust us, and they say, well, this is the right person for this particular, and that's why I have you on the air. For clients of mine that are looking to do some estate planning, just give me a call, and I'll get you David's information. Do you want to give the public the phone number for the law firm?
Yeah, I will do that.
Sure.
Our number in Woodbury is 203-263-0330.
All right, David Sfara, and congratulations to your beautiful wife, Mara. She's in London right now. She is an artist, and I hope she's doing great with her opening.
Okay, thanks, Michael.
Talk to you later. Bye-bye.
Bye.
All right, take our second break. We'll come back. Oh, that guy's so nice and mellow, isn't he? He's easy peasy, lemon squeezy. All right, we'll be back. Medicare and You. Talk to you soon.